Okay, psychological injuries. Psychological conditions never come up, hardly ever come up with the initial allowance of a claim. It's usually an additional condition. And it doesn't seem to come up until TT is cut off. So nobody's depressed until they don't have TT anymore. And they don't usually know it until their lawyer tells them that they might be depressed. And if they are, they might get 2 more years of TT. So the game is usually somebody has an allowed physical condition. We work for years to get them at MMI. We finally get the commission to say they're MMI. TT is cut off. Then it's not in the medical records that they're having any issues, but their attorney sends them to their doctor who says, oh yeah, major depressive disorder, he needs to be off work for another 2 years. And so they get that allowed, and that's off. They're off and running with TT again, and then we're working again to get people at MMI. So it can be kind of a big deal. Psychological conditions also tend to have a high PPD award for some reason, permanent partial disability, so they can be quite costly. I want to start at the beginning with the statute. The statute is 4123.01c, and that's the definition statute for workers' comp. And it kind of says injury is an injury except when it's not an injury, and then there's a list of things that are not an injury. And one of those things is a psychiatric condition. A psychiatric condition is not compensable except where the claimant's psychiatric conditions have arisen from an injury or an occupational disease sustained by that claimant, or where the claimant's psychiatric conditions have arisen from sexual conduct in which the claimant was forced by threat or physical harm to engage or participate. So what does that mean? Well, basically that means you can't have a standalone claim for a psychiatric injury. If that's the only harm, it's not compensable. So Florence was driving and she hit Archie in our fact pattern and he lost his legs. Now, Florence hurt her back too, so she has an allowed physical injury. But if she was not hurt in this scenario at all, but the mental strain from hurting Archie and seeing him lose his legs caused her to have PTSD or depression, something like that, she would not have a compensable claim under Ohio law. She has to have a physical problem. It can also come from an occupational disease, but we don't see that very often at all. So for our purposes today, I'll usually say injury instead of injury or occupational disease. But you could have asbestosis or something like that that causes depression. We just don't see it very often. The sexual assault part of the statute was added in 2006, so you can have a sexual assault that does not result in a physical injury, but you can have depression or PTSD or whatever from that, and that can be an allowed claim. I have not seen that, but I guess it's there, it's available. Okay. Okay. In 2001, there's an interesting case, goes to the history of psychological conditions before the statute changed. This is Bailey. Bailey had a really bad day at work. He was driving a tow motor, and he ran over a coworker and killed the coworker. Bailey was not hurt, but somebody else was injured. And so his attorney argued that his psychological condition, he suffered from severe depression, came from a physical injury. It wasn't Bailey's physical injury, it was the other guy's physical injury. And under the old statute, the Ohio Supreme Court said, yes, that's compensable. And then in 2006, they added the language, they added the physical injury to that claimant. So it has to be the claimant's own injury. So Florence, in 2001, had she not hurt her back, could have used the injury of Archie to have an allowed claim. But now it has to be your own physical injury. And that was Senate Bill 7. In 2006, Senate Bill 7 did a big overhaul in Ohio workers' comp. Okay, so the language in the statute, arisen from an injury or occupational disease, what do these words mean? And the rest of my presentation really surrounds this arisen from an injury or occupational disease. There's been a fair amount of case law in the last 5 or so years. This Jones versus Catholic Health Partners. In this claim, the claimant worked at a hospital. There was a prison inmate who came to the hospital for treatment, took her hostage apparently, and took her, at some point had her wrist and slammed it against a wall, broke her wrist. And the employer argued she has PTSD, but it's from being taken hostage by a prison inmate, not from this wrist fracture. And what the court said is, this is the 7th District, that it doesn't have to be the sole cause of the PTSD, this physical injury. If both taken together cause a psychological injury, then that's compensable. Now, had she just been taken hostage, hadn't been hurt, then that would not be compensable. So the big case is this Armstrong case, and I know we've talked about this before, but it's sort of evolving. And Armstrong was a dump truck driver, and he was stopped at a yield sign completely, and he saw a car behind him coming at a high rate of speed, and he knew the car was going to hit him, and he watched it hit him. And it hit him so hard that the car kind of went underneath the dump truck, and the driver died. And so Armstrong had the typical rear-ending injuries. He had a cervical, thoracic, lumbar sprain, strain, but nothing severe. The other driver died. And this went all the way to the Ohio Supreme Court. He had PTSD. And the court said the PTSD was not compensable because his physical injuries were not the cause of the PTSD. So he did have an allowed claim for soft tissue injuries, but those injuries did not cause the PTSD. It was actually having the other person die in the incident. He got out of the car and saw the person who died. And so from that has come a lot of case law. So what the Armstrong court said was a causal connection must exist between claimant's physical injury and the claimant's psychological condition. The hearing officers hate this case. They are looking for any reason to not go with the Armstrong decisions. And what happens is, a lot of times we get reports about depression and everything's kind of meshed together. The person has a loss of income or a loss of status, loss of job. The employer's mean to them because they keep denying their narcotics. The employer's counsel is mean to them. And all this taken together caused their depression. And so what the claimant's counsel like to argue is it's all from that incident. This is what led to the depression, and so it should be compensable. And what we have been arguing based on Armstrong is it has to be from that physical pain, the physical injury, not the things that flow from it, like loss of job and problems dealing with the bureau. Has to be the actual physical injury. Let's see. Sometimes it's hard to tell, though, from the reports exactly what the depression's from. So it's important to read those reports carefully because it has to be from the physical injuries. But this is a classic example of this Hippoly case. Claimant was hurt at work, hurt his back, and he couldn't return to his former position of employment because of the restrictions related to his allowed conditions. And so his employer placed him in the cafeteria. He didn't like that. He thought that was demeaning, that he had to work in the cafeteria. Oops. And this led him to develop major depressive disorder. And the court said his major depressive disorder is not compensable because the depression is related to his loss of income and his status and not the back injury. Even though he suffers from a back injury that was severe enough to keep him from his former position, it wasn't what actually caused the depression. Okay. Well, that's weird. Okay, I had that in there twice. Okay, Johnson versus OSU Cancer Research Hospital. There's a lot going on in this slide. There's a lot of technical stuff. But the story behind it is a little interesting. The claim was allowed for a lumbosacral sprain, and claimant asked for it to be additionally allowed for a disc herniation. And the disc herniation was disallowed. He gets a report from Dr. Drown, and Dr. Drown says his back hurts, and that's causing him to have major depressive disorder. The commission said good enough and allowed it for the major depressive disorder. And the company said, wait a minute, it's disallowed for the herniated disc, the more severe condition. And so how can his major depressive disorder be related to this sprain and not the herniated disc? And they requested reconsideration after the SHO. It's a means to get the third hearing if you're not familiar. So they got a full commission hearing. And the full commission granted reconsideration and overturned it. It said the major depressive disorder is probably related to the disc herniation. Dr. Drown didn't even talk about the disc herniation. He just said back hurts, that makes him sad, he has major depressive disorder. So all the technical jargon is here. The claimant filed a mandamus action. And what they said was the commission should not have granted reconsideration because in order to get that third hearing, there has to be a mistake of law or a mistake of fact. And they said that decision that there was a mistake wasn't warranted. They shouldn't have had a third hearing. But the magistrate took the matter on the merits and agreed with the commission that this should not have been allowed. And the court said the whole issue was moot, threw it out, and said you were actually supposed to take this to common pleas court. So this doesn't have a lot of binding effect, but it's an interesting way to look at Armstrong, that the mental condition has to relate specifically to the specific allowed condition. Bradley versus ODOT is sort of similar. Claimant had RSD disallowed in the claim, and then the commission added major depressive disorder. Here the company filed an appeal pursuant to RC 41-23-512 in the common pleas court, which is the proper venue. And the company argued since RSD was disallowed, and claimant's doctor said the RSD is what caused the major depressive disorder, then you have to disallow the major depressive disorder. And the court agreed and granted summary judgment, which seems like a no-brainer to me. If the doctor bases it on RSD, a disallowed condition, that should be disallowed. But it seems to happen all the time. And I think it's because you just get these general opinions with the body part. Back hurts, so the depression's related to that. So we can use Armstrong to argue that it has to be specific to the allowed condition. Okay, what about substantial aggravation of a psychological condition? Here, Florence was seeking substantial aggravation of the generalized anxiety disorder. We've been arguing that you can't have a substantial aggravation of a psychological condition, and until yesterday, I didn't have any opinion on this. The commission finally issued a decision on this, so I had to scramble to read this opinion, but until yesterday, there was no opinion. We kept arguing you could not have a substantial aggravation of a psychological condition, and the commission kept dodging it. And this is what it's based on. I'm going to go back to the statute. Okay, it says psychiatric conditions which have arisen from an injury or occupational disease. So the argument goes, if it was pre-existing, how did it arise from the injury? So we've been arguing that the language of the statute precludes a substantial aggravation of a psychological condition. And it's been a little funny because we filed briefs in something like 5 cases, and the commission just dodges it. Either they disallow it, they allow it on a direct basis. We've had a couple where they found, pursuant to Armstrong, that the psych condition is actually related to loss of income or something like that, other than that. But just yesterday, the full commission issued an order, and they said you can have a substantial aggravation of a psychological condition. We haven't seen this in court at all, just the full commission. And what they said is the substantial aggravation statute says that you can't have an aggravation of, you can't have a allowed condition for a pre-existing injury unless that's substantially aggravated. And so the word pre-existing condition, that condition can be a psychological condition, so therefore you can have a substantial aggravation of a pre-existing condition. Now, Rob Stolt talked a little bit about how you need these objective diagnostic findings, objective clinical findings, or objective test results to support a substantial aggravation. And this order, they don't list what that is. So this order is a little defective, but it made me wonder what would be the objective diagnostic finding, clinical findings, or test results where you compare the pre-injury status to the post-injury status to show that their condition worsened. And then, how does the commission determine when a psychological condition has returned to a level that would have existed without the injury? How can we tell where their depression would have been had they not been injured. So I think that's going to be a tough question. So what does this mean for Florence and her anxiety disorder? Well, we argue Ohio law does not recognize the substantial aggravation of a pre-existing psychological condition. We can keep arguing that. And maybe eventually we'll get this into court and have the court determine the issue. And then, but I think the bigger argument is to argue the anxiety disorder was caused or aggravated by hurting Archie and not the allowed back strain. Her claims only allowed for a back strain, and I think she had chronic back conditions prior to this. It's probably more likely that any anxiety she suffered is not a result of her back hurting, but a result of Archie's condition. You have to get a doctor to say that, of course. And argue even if the anxiety disorder was caused by the back pain, the pain was related to prior chronic back pain and not this new strain. And you have to look at the claimant's doctor, and if they say it's just related to back pain and not specifically to this allowed new condition, that's an argument as well under Armstrong. You guys have been very quiet. Everybody have any questions? No? Okay. All right, I think we're going to go ahead and take a break.